A couple of weeks ago, I had the opportunity to sit in on one of the sessions of the International Criminal Court. The case I watched involved the prosecution of two men on charges of war crimes and crimes against humanity in the Central African Republic. The two men, Alfred Yekatom and Patrice Edouard Nagasona, are accused of a number of crimes, the most egregious of which included the conscription of child soldiers into fighting during the sectarian violence that rocked the country in 2013 and 2014. But what exactly is the International Criminal Court and how does it work? Hey everyone. I'm Noah Zerbe. I'm a professor of global politics at California State Polytechnic University Humboldt. Welcome to Global Explainer, where we examine the theories and concepts behind current events in global politics. The case against the two defendants I witnessed is illustrative of the role of the International Criminal Court, or the ICC. The conflict in the Central African Republic largely pit the mainly Muslim Seleka rebel coalition against the primarily Christian anti-Balaka militias. The violence that rocked the country resulted in thousands of deaths and displaced hundreds of thousands of people, and both Yekatom and Nagasona were senior leaders in the anti-Balaka militias. The case against them at the International Criminal Court stems from their leadership roles in those militia groups. But in general, cases against defendants at the ICC aim to hold individuals accountable for widespread atrocities committed during conflicts like that in the Central African Republic. And the cases are often viewed as a step towards justice for the victims and a way to help stabilize the fragile peace process in post-conflict countries. But the ICC's involvement in the Central African Republic goes beyond these high-profile cases. It's also about providing justice to the countless victims who have suffered unimaginable horrors. It's about confronting the culture of impunity that has plagued the conflict zones like the CAR for too long. However, navigating this path to justice is far from simple. The ICC operates in a complex political landscape where cooperation isn't always guaranteed. The CAR government, international partners, and the ICC itself must work together to ensure that justice is served. The International Criminal Court operates on the basis of its foundational treaty, the Rome Statute, which provides for the prosecution of individuals accused of the most serious international crimes: genocide, crimes against humanity, war crimes, and crimes of aggression. The legal process surrounding prosecution is often long and complex. Before even launching a full investigation, the Office of the Prosecutor, or the OTP, conducts a preliminary examination to determine whether there is a reasonable basis to proceed. This often involves assessing jurisdiction, admissibility, and the idea of the interests of justice. Most frequently, the prosecutor initiates an investigation based on a referral either from a state party to the court or from the UN Security Council. Alternatively, the prosecutor can choose to act proprietary motu, Latin for of their own initiative, usually based on information received from other sources like non-governmental organizations or individual requests, though when operating in this capacity, judicial authorization also has to be received from the pretrial chamber in the court. The pretrial chamber is a three-judge panel that oversees investigations and the initial proceedings of cases to ensure they're conducted correctly and fairly. During the investigation phase, the Office of the Prosecutor gathers evidence from various sources, for example, by interviewing witnesses, collecting documents, and conducting on-site investigations. At the end of the investigation, the prosecutor, if they believe there's sufficient evidence to move forward, requests the pretrial chamber issue arrest warrants or summons for individuals to appear. Now, the ICC lacks its own police force and has to rely on the domestic police forces of party states to enforce its arrest warrants. This has sometimes led to challenges bringing high-profile defendants to trial, as some party states have occasionally declined to enforce arrest warrants despite their treaty obligations to do so. Once one or more of the suspects are in ICC custody, a pretrial chamber conducts an initial hearing in which the accused is read the charges against them and informed of their rights during the trial, after which a confirmation of charges hearing is held where the pretrial chamber decides whether or not there's sufficient evidence to proceed with the trial. If a pretrial chamber concludes that sufficient evidence exists to move forward, the case moves to the trial phase, which is conducted before a trial chamber, again consisting of 3 judges. Both the prosecution and the defense present evidence and call witnesses. Victims are also offered the opportunity to testify, and the proceedings aim to be fair, expeditious, and transparent with respect for the rights of the accused and the interests of the victims. Once both sides have presented their cases, the 3-judge panel issues its verdict. If a defendant is found guilty, the trial chamber determines the appropriate sentence, which can involve a maximum sentence of life imprisonment, but can also include reparations for victims, including restitution, compensation, and rehabilitation of the accused. The trust fund for victims can also assist with reparations. Both the prosecution and the defense have the right to appeal the trial chamber's decision, including the verdict, the sentence, or both. Any appeals are considered by the appeals chamber, whose final decision is binding. The appeals chamber is comprised of 5 judges from the International Criminal Court who did not participate either on the pretrial chamber or the trial chamber. The decision of the appeals chamber is final and cannot be appealed to another court or chamber. The ICC doesn't have its own prison, so if an individual is convicted, their sentence is enforced by a state that has indicated its willingness to accept the sentenced individual and has been designated by the court as an acceptable recipient. Throughout the entire process, the rights of the accused, including the presumption of innocence, the right to legal representation, and the right to a fair and speedy trial, are protected. Additionally, the safety, dignity, and well-being of victims and witnesses is also a core concern of the ICC throughout its proceedings. But if you watch a case, and I'll link to the ICC's website where many of its cases are live streamed, you'll notice a couple of differences between the ICC's process and many domestic courts. First, the ICC draws on an interesting mix of civil law and common law traditions. The most notable way that this plays out is in the role of the presiding judges. In the common law tradition, judges are viewed as neutral arbiters, adjudicating disputes between the 2 sides, but remaining neutral between them. But in the civil law tradition, a judge's primary obligation is to determine the truth. As a result, judges often interrupt court proceedings to ask questions of witnesses, something that's relatively uncommon in the common law system. Other civil law traditions found in the ICC include the confirmation of charges hearing, which is similar to the examining phase in many civil law traditions, and is where the pretrial chamber determines whether or not there's sufficient evidence for a case to proceed to trial. This phase is often not seen in common law traditions. Additionally, the ICC provides pretty wide latitude for victims to participate in the proceedings, including presenting their views and concerns to the court, another element common to civil law traditions. From the common law traditions, the ICC draws on many of the disclosure requirements under which prosecutors must share potentially exculpatory evidence with the defense, as well as protecting their due process rights. For example, ensuring the accused have a presumption of innocence, the right to cross-examine witnesses, both of which are hallmarks of the common law tradition. Further, rather than relying on a single judge, as is normally the case in domestic trial courts, the ICC uses multiple judge panels to hear cases. Both the pretrial and the trial chamber are comprised of 3 judges, while the appeals chamber is comprised of 5 judges. In total, there are 18 judges elected to the court by the Assembly of Party States, which includes all of the countries that have ratified or acceded to the Rome Statute, the treaty which established the ICC. Judges are elected by a 2/3 majority vote of the Assembly in a secret ballot and serve a 9-year non-renewable term on the court. To be eligible to serve as a judge, candidates have to have at least 9 years of legal experience as a judge, prosecutor, attorney, or in a similar capacity, and have to be nominated by their home government for the position. Consideration is also given in the nomination process to ensure there's a gender balance in the court and a regional balance of judges on the court. And one other notable difference between the ICC and many domestic legal systems is that there are no jury trials at the ICC. All decisions are made by a panel of judges who hear the case. Despite its laudable focus on prosecuting violations of human rights around the world, the ICC has come under some criticism on a number of fronts, commonly around its lack of enforcement mechanisms, its inability or its need to rely on state parties' cooperation in order to arrest suspects and detain them. The lack of universal participation in the ICC has also been noted as an area of concern. While some 123 member states have ratified the Rome Statute, many of the world's most powerful countries, including China, Russia, and the United States, are not party to the ICC and thus not subject to its jurisdiction. But perhaps the most powerful criticism of the ICC in recent years has been the accusations of racism and Eurocentrism on the court. Several African governments have accused the court of only punishing leaders from small, weaker states while ignoring crimes committed by leaders of richer and more powerful states in the international system, and thus leading them to conclude that the court is a tool for neocolonialism in Africa. This accusation has been amplified by the fact that the vast majority of cases before the International Criminal Court have been trials of African leaders, and the ICC's first non-African case didn't even emerge until 2016 when an investigation into potential war crimes committed during the Russian invasion of Georgia was launched. Despite these criticisms, the ICC remains an important, albeit imperfect, component of the global human rights architecture. But that's it for now. If you found this helpful, please click the thumbs up button and consider subscribing to catch future explainers as they're released. If you have any questions, please leave those in the comments section below, and I'd also welcome any suggestions for future explainer topics. Thanks for watching, everyone. Bye.